The only people who don't want to disclose the truth are people with something to hide.
This court is now in session. Be seated.
All right, thank you for your patience. Judge Witt recused himself in this case, and we have Judge Farson joining us to hear his final appeal. So would you call the case, please?
State versus Walter Francis Fitzpatrick.
Good morning, Your Honors.
Good morning.
U.S. military veteran, and as a veteran, I recognize how rare it is to be representing an honor graduate from the United States Naval Academy in Annapolis on a misdemeanor conviction. Having seen the court's familiarity with the cases and briefs this morning, I'll jump right to my first point, which might help the court in deciding this case. The briefs talk about Rule 401, Rule 403, and hearsay. And I just wanted to point out to the court that the record clearly reflects that the decision to deny the defendant the right to testify about the facts supporting his necessity defense came from the court's decision to make a new categorical exception to the statutorily codified defense of necessity. And from the record, I'm quoting the court, the defense of necessity justification does not turn vigilantes loose to patrol the jury selection process. The defense of necessity doesn't allow someone to purloin an official government record. This objection is sustained. And part of what my point here is that when the objection was raised to the testimony that was being offered, the state's objection never stated what his objection, what the grounds of his objection was. He never stated a rule or even explained what the objection was, and from that point we immediately went into dismissing the jury and going to an offer of proof. During the offer of proof, the defendant, Commander Fitzpatrick, explained that he had been investigating the jury selection process in Monroe County and other counties, and that he had reason to believe that at a minimum the selection process wasn't being done in a manner that followed the state's laws, and at least there was a possibility that this was being done in a way that would, whether intentionally or not, lead to juries that were biased one way or the other. He took his concerns to an FBI agent, and the FBI agent told him that if the FBI was going to do anything more with this matter, that he needed to bring them hard evidence. He then went back to the court to watch the view the selection of the jury, and he saw what he was convinced was illegal activity on the part of at least one judge. He was then downstairs with the jury a little bit later. The jury was brought back upstairs for a meeting that he was specifically told he couldn't participate in, so he waited in this room, and he realized that amongst other documents on the table were documents that he had seen the judge handwrite notes on the questionnaires that the jurors had filled out, that the judge had spoken to in the room and questioned about their questionnaires, shuffle them, select certain ones, staple them together, and now those very documents were on the table in front of him. Now, he knew that if he left those documents there, even if he was able to find out later, according to state statute, the names and phone numbers and addresses of those jurors was going to be published. It has to be. That wasn't the information on those documents that he wanted to take to the FBI to get them interested in investigating this matter. What was on the documents, what was important, what made them evidence, was the fact that he had seen this judge make notes, hand select certain jurors for the grand jury, and staple them together. I don't think it's even. I don't think the state even has argued that those documents wouldn't have been destroyed. In fact, there's testimony from the clerks themselves that those documents are regularly, after the information on them is transferred to the computer, those documents are destroyed. So, being a graduate of Annapolis, the commander never denied he took these documents. That wasn't his defense at trial. The entire point of his defense at trial was to argue under the code, under the statute, that taking the document, removing the documents from the court was absolutely necessary for preserving evidence. Now, there's discussion in briefs, and there's discussions there was discussion at the trial that as to whether or not this fit the typical use of the necessity defense. And we absolutely, right up front, say, no, it doesn't. The classic law school example of necessity is something similar to what was argued before this court in just this last case. We've got a situation where life is at risk, and if someone doesn't take action that is illegal, the life is going to be lost, or at least, the harm, it might be lost. Absolutely, that's the standard necessity defense situation. However, the legislature of this state wrote a statute codifying the necessity defense. It didn't leave it to precedent. It specifically took it upon itself to write a statute. That statute has two elements. Those two elements are intentionally broad. They're broad because it leaves it to the jury to decide the critical factors, the facts that are being applied to this defense. Those elements are that the defendant reasonably believed that the action he was taking was necessary to prevent a greater harm. It doesn't say to preserve life. It doesn't say anything about any specific circumstances. It's intentionally broad. That broadness is balanced with the second element. The second element is that the crime that was committed by the defendant, the harm that was intended by the legislature in making that action illegal, was less than the harm that was actually caused by breaking that under the circumstances presented. In this case, we had unopposed testimony from the state's witness saying that the amount of harm caused by taking these documents was that they had to go get the court reporter that was across the hall, listen to her recording, and get the names and phone numbers and addresses of the jurors that had been there because they lost their names and phone numbers and addresses. It took all of maybe an hour of the court's time. Now, obviously, this is a harm, but the harm that was intended to be prevented was the potential corruption of a jury system in the state of Tennessee.
Doesn't the harm have to be imminent?
Yes, Your Honor, and the harm here was that the evidence that was necessary to get investigators investigating this potential crime was absolutely going to be destroyed. And it's another.
Well, no, but I mean the necessity defense requires that the harm, you said just now, the harm was a potential corruption of the jury system in Tennessee.
Yes, Your Honor. And
that harm is the harm that would have to be imminent.
I understand, Your Honor.
Under the necessity statute.
Absolutely. Let's talk about, and I've thought about this several ways, and I understand what you're saying. The other harm that's being prevented here is the destruction of evidence. We have throughout the country exigent circumstances doctrines where police officers are allowed to kick down someone's door and go into a home in what would otherwise be a violation of a very fundamental constitutionally protected right, because they believe, they have a reasonable reason to believe, I believe is the standard, that there is evidence that might be destroyed. Exigent circumstances, I don't think it would be a good idea to decide that there's a category, or that we can't apply the same standards to a defendant defending himself against a criminal charge that we apply to police officers who are breaking down someone's door.
Well, but at that point, your client hadn't been charged with a criminal charge. The criminal charge arose out of his taking the grand jury documents.
Yes, Your Honor, but we're trying to establish the imminent harm that was prevented by the illegal action. The imminent harm was the destruction of evidence. That imminent harm is preventing destruction of evidence balanced against the harm that was caused by taking that evidence. The harm that was caused by taking that evidence is undisputedly a half an hour to an hour of court personnel time versus destruction of evidence that could lead to widespread, or at least, potential corruption in the jury selection process.
So what was the basis of your client's reasonable belief of imminent harm, that these writings somehow showed that the grand jury system was being corrupted or whatever?
He saw a judge upstairs, and understand that the codes, the jury selection codes require that the juries be selected, and this was actually a selection of the grand jury. The jury codes require selection be done in a manner that doesn't include human selection of individuals, but can't even have to prevent that possibility. Here was a judge up here, and I don't know how widespread this is.
The gathering of veneer from which the grand jury should be selected, or the actual selecting of the grand jury?
This was the selection of the panel that became the grand jury in
So taking the pool you have to choose from and coming up with your grand jury.
Shuffling through them, writing notes, questioning them, and then picking the ones that you want and stapling them together. Those are the ones that became the grand jury in that county.
What did the notes say?
Honestly, Your Honor, I don't remember.
So the name.
And I don't think the defendant knew at the time that he took the documents. So
that's my point. What reasonable basis could he possibly have of this imminent danger or injury when he had no idea what the writings were on those forms?
Because it is illegal for the judge to even take
to make those some forms that are mailed back to court.
Your Honor, according to the codes, it is illegal for that judge to use, for that court to use any system that would allow the court to select individuals out of the group. And that's what can happen.
That these grand jurors were not selected from the pool by random.
Exactly, Your Honor. And one point that I want to make is we don't have to prove at his trial, in order to raise the necessity defense, we don't have to prove that those allegations are true. We certainly can't go and prove that there's corruption going on in the jury selection process. All we have to do is raise the question that, and it's a jury issue whether or not that belief was reasonable. Absolutely, it's an objective standard, but here we've got a situation where the judge denied the defendant's right to testify regarding facts. Everything we're discussing was kept away from the jury. So
let me ask you this: is the assuming that the trial judge was not following the rules of criminal procedure for the selection of grand jury members, is that a crime?
Well, it's certainly evidence.
It may be error, and it may give rise to a new trial if someone's indicted by that grand jury that's improperly selected. But is it a crime?
It could be a crime. It is a crime if it's being done intentionally. It's a crime if it's being done in a manner that allows where the juries, the grand jury that's being selected, consists of individuals that are going to have a bias in either direction.
What crime is it?
It would be corruption. It would be
corruption. There's no crime like corruption. It has to. We have a code that what crime is that.
I understand, Your Honor, and I honestly can't cite a specific crime. What I can tell you is that the FBI, according to the testimony, was interested in finding out whether or not this was actually going on. He was instructed to bring them evidence, and I don't know about you, but I would certainly think that even if there's not an individual that's going to be indicted for that or even slapped on the wrist, if there's something happening within the jury or within the court system in that county that's not according to statute and possibly could create bias, it's certainly something that's important enough to preserve evidence to get changed.
Well, if it was being done with a view toward rigging a particular grand jury to get a particular result, then it might be official misconduct.
Certainly.
But if it was simply a failure to follow the rule, that's not a crime. That may be an error in the judicial process, so that a new trial would be for anyone who's indicted by that grand jury. I'll grant that. But I know of no crime failing to follow the rules of criminal procedure.
I understand, Your Honor, and let's say I completely agree with you. The point here is that this is a jury question. The question under the necessity rule is, was the harm to be prevented, to be presented at trial, which was denied? Did that outweigh the harm that was to be prevented by the law against the crime that was committed? These are jury questions that need to be, absolutely everything we talked about in the last 5 minutes are things that should have been presented to the jury. And one thing I wanted to bring up is, under the United States and Tennessee State v. Flood, under State v. Flood, a defendant is denied his right to testify, his United States constitutional right to testify, if the denial of his testimony, let me just get the quote from Flood. There it is. This is State v. Flood, 219 SW 3rd 307, Tennessee 2007. An exclusion of evidence is unconstitutional when it significantly undermines fundamental elements of the accused's defense, and that's quoting United States v. Chambers, a Supreme Court case. And in this case, in Flood, the court found, if I remember correctly, that the defendant in that case did not believe his right. However, it went on to distinguish that case from United States v. Chambers. And it made the point that in Chambers, the person was essentially denied any defense. And it wasn't even nearly as stark as this case. In this case, we had a defendant that was admitting that he took the documents. And his entire defense was, and it had to be done, and here's the reason why. It's the necessity defense. The court does not have the authority to take a codified defense and say, well, I'm going to say that it doesn't apply categorically when you have these circumstances. It's simply not within the court's authority to do that. If we've met the elements of the defense, then the court is required to not only allow that testimony, which wasn't, as far as anyone, the record shows, wasn't inadmissible for any other reason, but was simply excluded because the court didn't think that this defense should be presented to the jury. That denied, not only usurped the authority of the legislative branch and got rid of the need for a jury, but it also denied the defendant under Flood and Chambers the right to testify in his own defense, his only defense. The jury was out for a matter of less than 5 minutes. I mean, honestly, I didn't know what to say to them at closing argument because that was our entire case. If I could reserve the rest of my time.
Okay.
Thank you.
Please report again, Kyle Dixon from the state of Tennessee. Of course, the jury instruction issue and the admission of evidence issue are dovetailed in this instance because, of course, necessity is not approved. And as the defendant contends, that was due to the judge's ruling regarding the admissibility of the evidence. It's the state's position that the offer of proof made consisted entirely of irrelevant evidence. It was not probative of any issue of trial, and whatever probative value it had, as the trial court correctly ruled, it ran great risk of confusing the jury.
So we have a proffer in the record, right?
There is a proffer.
Okay. So we know what proof would have been put on had it been allowed.
Exactly. The proffer was properly made and consisted mainly of what you've heard here today during defense counsel's argument, was that the defendant met with an FBI agent, explained his concerns, and was told, as I'm sure law enforcement officers tell citizens every day, there's not a crime here. Based upon what you've told me, you need more evidence. Now, that statement by the FBI agent, completely innocuous, somewhat vague, cannot be read to create a necessity on the defendant's behalf. to steal government documents. The other half of this, what the defendant viewed the trial court doing, the trial court looking through papers, the trial court taking notes, things that occur every day in this court and trial courts across the nation. Any thought of misdoing was completely speculative on the defendant's part at that point. And of course, the key under the statute is that whatever fear of imminent harm there is, it must be based upon an objectively reasonable belief. It cannot be said that it's objectively reasonable for a person to sit in front of a courtroom, watch a judge take notes, look through papers, and assume that wrongdoing is taking place, and therefore have basically a license under the statute to steal those government records. That is not the purpose of the necessity statute. The evidence offered by the defendant on this issue was not relevant. It is not probative of a necessity defense in this case, and it was properly excluded by the trial court. If there are no questions, the state would ask that the court affirm the conviction.
All right. Mr. Arian? Am I pronouncing your name correctly?
Yes, Your Honor.
Arian?
Yes, Your Honor. And that's actually rare. Say irony. Your Honor, the state's argument is essentially that we should get rid of the jury system. Everything that I just heard state's counsel say relates to arguing witnesses they could have called in rebuttal and arguments that they could have made in rebuttal and didn't. It didn't because the court denied the defendant the right to testify and denied the defendant the right to present facts in support of his defense. I mean, arguing that the evidence is irrelevant. Pardon me, Your Honors. I mean, we're all very familiar with the relevance rule. Any tendency. We're talking about going and talking to a FBI agent, having the agent say, well, I need some more evidence. We're talking, and by the way, there was a discussion in the state's brief about, and we discussed it also in our reply brief, about the fact that the testimony of the FBI agent, or the testimony that was proffered during the offer of proof by the defendant about what the FBI agent told him was hearsay. And that is, I just want to make the point that that's not true. It goes to the state of mind of the defendant at the time and reasonableness of what he believed those documents represented. What was the basis
of your client's belief that some criminal activity or corrupt activity was afoot simply by it was based on, I assume, more than just the judge writing on the grand jury documents? Yes, Your Honor. There's a long history of the defendant investigating jury selection processes. He has attended many grand jury selections in a couple of different counties, and he has become kind of an expert on the statutes on how selections are supposed to be done. There's certainly some counties that kind of play fast and loose with it. Who knows whether or not, which ones are corrupt. But this particular county, he had attended many grand jury and pettit jury selections and had talked with jurors. There was some evidence about a particular grand juror that he talked with that day. But at the bottom, at the end of it, it is very clear in the statutes that judges, or that the court is supposed to have a system that does not allow for human intervention in selecting those grand jurors or pettit jurors that are on the panel. And in this particular case, it was very clear that exactly what happened was this judge shuffled through the questionnaires with the names and picked the ones that she wanted on this particular grand jury panel. And whether or not she had, that might just be the way she's always done it, or it might be something nefarious. But the point is, it violated the statute, at least in the reasonable, I think, opinion of the defendant. And he wanted to bring that to the FBI and find out what the notes were.
But again, these are issues and arguments that should have been raised and presented to the jury and weren't.
So you're seriously saying that your client observed a criminal court judge take the cards of all the people who were summoned in for grand jury and say, I want this one, I'm picking this person, I'm picking this person, I'm picking this person, I'm picking this person, to come up with a grand jury?
Yes, Your Honor. That is exactly what I'm telling you. Yes. And that your reaction reflects the seriousness of this. It might not be true. I believe it is because I know the man, but I mean, this is something that's tertiary. I mean, this really doesn't
Well,
have...
it's pretty simple to determine whether or not you put all the names in the box and draw something out,
And
or
that-
you put them all on the desk and you hand pick them. I mean, that's not real complicated.
Yeah, I agree, Your Honor. That's how serious this is, and that is absolutely, according to the defendant, what's going on in that county. And again, these issues wouldn't be...
What Judge Smith said, the remedy would be to dismiss those indictments.
Before we even get there, my argument is that the defendant certainly had relevant evidence in support of his reasonable belief that something was going on, and that those documents were evidence that were going to be destroyed, and it was important enough for him to take those. We're talking about a man who spent 20 years of his life dedicated to defending this country and the Constitution, and he made a decision to knowingly break the law because he thought it was necessary, and that defense was denied him.
Did he take them to the FBI?
He took them to a reporter, and he made sure that she didn't release any private information on them. That he just sent them to he sent them to a reporter in order to make sure that he figured he was probably going to get arrested, and his house was going to be searched, and he wanted to get them out of his house.
Well, why didn't he take them to the FBI?
That was the plan, but he got arrested before he could, Your Honor. And again, all of this is completely outside of the scope of the trial. The trial was, there was something going on, and whether or not his belief was reasonable was something that should have been discussed. And also, I want to say, when you look at the offer of proof was limited, to say the least. It was an offer of proof that established the necessary facts to show that we were trying to raise a necessity defense. If the defense had brought witnesses or these arguments, then there would have been more evidence in support of the reasonableness of his actions. And again, at the end of the day, it's a jury question. If the defendant is not given a new trial here, we're essentially saying we don't need juries anymore, we don't need the legislature, we might as well go home because we're not going to follow the statute because we decided that it doesn't apply here. And we really don't even need the Bill of Rights because, we don't need to have defendants testify against themselves. I hate to hyperbolize, I really do, but that's how important these issues are, and in a little misdemeanor case. Did you hear? The reporter was directed to send the documents to the FBI after she received them, and that's what happened.
You've about used up your time.
Thank you very much, Your Honor.
So we understand the position of both the government and yourself.
Thank you.
So thank you. Thank you. Does that conclude our morning copy?
Yes, Your
All
Honor.
right. We're standing adjournment until the December 2nd.
All
Okay.
rise. This court stands adjourned until December the 17th at 9:30 a.m.
Time is 10:58 hours.
The only people who don't want to disclose the truth are people with something to hide.